So that's why I always tell you guys, always, if you can't get a ruling on the record, you've got to make written objections and go up on a writ, right? Or at the very least, if you go up on a cert, it's going to probably get remanded, because that's a big deal, especially in federal court, for a judge not to make rulings. But you'll be languishing in jail while you're waiting for all this stuff to happen. So it's better to get those rulings now, during the time that you're in front of the judge. And so I make up for that by filing written objections if the judge refuses to rule on them, and demand a ruling on the objections, because it shows an abuse of discretion by the court for failing to rule on the objections. And again, this is federal law. So this is Sixth Circuit. So it's only persuasive authority for the Arizona court in this case. It's not mandatory authority, all right? So let's just sort of get into it. Well, I kind of broke it down to you, but ultimately, after the court remanded and the district court reviewed the record, they found that the government met the requirements and they found no error. So they overruled the objections. I hope that makes sense. So they rejected. What the hell did I just do? Am I even on the right case anymore? Looks like now I'm on the wrong case. Let me go back. There we are. All right. So ultimately, because the trial court didn't state that the objections were overruled, but said the government could proceed, that's why the case got sent back. And here they're saying that they doubt Holloway's counsel did not know that the judge intended to admit the evidence only on the condition that the government later established the Enright Foundation by preponderance of the evidence. And they also found that the evidence which the trial judge used had been established was highly probative of Holloway's knowledge that the checks had been fraudulent, and that Holloway's sole defense was that she lacked this knowledge. Her counsel therefore had ample motivation to vigorously contest, regardless of how the trial judge disposed of the hearsay objection. So because of this, the upper court found, on the somewhat peculiar facts of this case, that the trial judge's failure to advise that hearsay evidence was only conditional did not prejudice Holloway. So they weren't buying it, and it got sent back. The trial court ruled on it, and she was found guilty. That's kind of the facts of this case. And I don't have a lot of time, guys, as usual. I don't want to revisit the entire case or read the whole brief, but you can look up the case yourself. And that case is, again, United States versus Holloway, United States Court of Appeals for the Sixth Circuit. And it's a 1984 case. And let me find you the citation if I still have it up here on the screen. Give me 1 second, guys. That would be 740 F. 2nd, 1373, Sixth Circuit, and it's a 1984 case. So we've got Lados done. And now we're going to go back into letting Lane Myers say his piece. So I just wanted you guys to get a little bit of a foundation. Now, the other day, I got the actual uncommentaried video from This Is a Public Service, but I'm going to continue on with his. And if there's too much commentary, I'm going to move it forward, because I like a lot of the comments that This Is a Public Service made. And now that I see some comments, by the way, did anybody throw me any super chats or memberships? Well, because I've been watching. If you did, I want to make sure to thank you, because I don't want to scroll up and lose my place here. But somebody says, never be your own lawyer. Well, yeah, I'd say that's fair, James. James said that. And, thank you. What's the matter, you? It's a 1984, right? 1984, like the year 1984, correct. And not to be confused with the George Orwell novel. But let's go ahead and get into the actual, and again, I'm not going to be watching the screen. So if somebody donates to me, please, one of my mods, let me know. And what I'll do actually to try to make this even easier is I'll try to do an overlay here so we can look at your comments, and I'll try to occasionally look at them. Actually, I'm not even going to be able to do that because I'm going to be playing his video. So forget that. Let's leave it as big as we can, and let's get into the actual video. Let me see if I can make it to where... Yeah, I'm just learning how to use this thing, guys. I'm using Restream. Okay, so you see me down in the corner. Hi, everybody. Good seeing you. All right, so let's get into it. Here we go.
Every single person, and I wish there would have been tens of thousands more. His amendment, his petition to amend Rule 122 is total and complete garbage.
Yeah, and that's a problem that I have with this case as well. So Matt Walker, as you'll recall, is the guy who lost the case where Lane Myers booed. And that's what prompted Lane to try to figure out, why is Matt Walker's wife, who works for a tax-funded university, working with the prosecutor's office? Allegedly, he found some information that they were sharing information back and forth, or that the law school was somehow assisting prosecutor's office. And so using public information from public tax-funded websites Lane located this woman and found the connection. Like, what's going on here? This is crazy. So he tried to get information from her using publicly available sources, not her private information. And because Lane was using his audio under 122H of an Arizona Supreme Court decision or ruling, rule of court, I guess, that he's allowed to audio record in court, and then he was live streaming it over YouTube. Well, Matt didn't like that. And many people say because it made Matt look really bad when Lane beat him in court. And if somebody has the link, I know that a lot of people have already uploaded Lane's videos that the court ordered him to take down. So if you guys have a link to a video showing that, put it in the sidebar so the audience can kind of see what happened. But many people are arguing that Matt took it personal. It hurt his ego. And so he tried to he did file a petition to make it basically unlawful for people to audio record in court. Somehow that was going to interfere with the justice system. And obviously I disagreed with that. And I wrote in opposition to that as a California and Texas lawyer that I thought that that was violative, and I thought that that was in poor taste, and it just had the appearance of impropriety. And many other people did as well. And I don't know what the result of that petition is, but obviously I disagree with that. I believe that sunlight is the greatest disinfectant. Give me a bunch of ones if you agree as well. And let's get back into the video.
It's trash. It's more trash from the legal loser, Malpractice Matt.
So, I ordered the recording from the FTR. You pay $35 to Tracy downstairs, and she hands you, she emails you a recording. In Shannon's own words, we're going to listen. So she goes and gets an injunction. This is the second one, because we're going to have to go back. This is the one that is technically still in place, because remember, there's still that in place too, like modify into the conditions of probation type thing.
That's a
injunction for harassment.
And I think you have an appeal pending. Is that right?
That's right.
But it's still in place.
Yeah, and I believe it's going to get overturned, and this is going to put egg on their face, but we'll get to that. And so Shannon Walker comes to Superior Court to get it.
So it appears as though, even though Lane's already pled out, that he's filed something to get the injunction overturned. And I'm not sure how that works, but typically when you plea out and plead guilty, I don't think there's a way that it can be unwound by unwinding a prior injunction. But Lane's bested me on more than one occasion. He's pretty smart, pretty crafty individual. So he's saying that at his hearing on whether or not he's going to get out of jail and on whether or not he's going to have additional restrictions on a probation or if he's going to be forced to do time. So let's keep listening to what this is Lane Myers, by the way, speaking in court. And this is another reason why I think it's really cool to be able to audio record, because if the court's recording, the video could just mysteriously disappear. So it's important that the public have the right to hear this. Let's keep listening.
An injunction. Little did we know that she had already came the day before and got an injunction, and then came back the next, when the judge wouldn't give her the conditions of social media, of taking away my social media, she came back the next day to get another one from a different judge. So at this point...
Prophet, that's exactly right. I've said it the entire time. Shannon Walker is Matt Walker's human shield. He did this because of his ego. This is all happening because of Matt's... Hold on, I gotta let my dog in.
I don't know what happened here, but it looks like something slowed us down. What do you want
to do with this one? She wants to dismiss it and start a brand new one. So I'd like to dismiss this one and start a brand new one. Judge Walton says, but with the same allegations?
Yeah, so what Lane's referencing is that based on Lane's research, once Shannon Walker dismissed her original request for injunction and then refiled another one that was essentially based on the same facts or facts that were within her possession, custody, control, and knowledge at the time she filed the original one, it was an unlawful injunction, in that the court had a legal duty to not entertain the new injunction. And so naturally, me as a trial attorney, I'm thinking, wait a minute, he may be onto something. If he's able to prove this, if Lane's able to prove this, he may be in a position to unwind the entire case. Now, I'm not sure if that's going to happen or not, but it definitely gives me pause for thought. I mean, this is pretty wild. So let's keep listening. It's pretty incredible. Lane's no dummy. I'm very impressed so far with what I'm hearing. Sorry, guys, I have sciatica. I got one of these leaning chairs where I can lean up against it and occasionally sit on it. And I'm trying to adjust my posture here because my whole leg is on fire right now. It's not easy for me to do these shows, guys. Just to let you know, I'm doing this because I really feel like, in my opinion, Lane got railroaded.
Shannon Walker says, correct. That's what I was advised to do. My hope is that the original one will be canceled, so that's not information that is available to anyone. Judge Walton. And to me, this is where
Coco, I don't know. I'm not sure. I've got a no contact order with Lane, so I don't know any of his plans or ideas. But we'll all see it unfold.
And this is the guy talking right now. He actually has an injunction against, well, Lane has an injunction or an order, a stay away order where he's not allowed to talk to this guy. And I've done my best to donate to his channel. This is a public service, and try to assist in any way I can. Since I'm not an Arizona attorney, I can't be Lane's lawyer. And I can't even give anybody legal advice about how to handle the case. And that's why I'm presenting it to you as if it's a case that I'd handled in California or Texas, where I am a member of both bars, to where I could potentially tackle it there. But I really like this guy, and I recommend that you like and subscribe to his channel. You can't expect people who aren't lawyers to know the law. And based on a lot of the YouTube lawyers who I've seen, these guys are complete buffoons. So, and they all just hate Lane, and they just want to trash him and put him down. And so I feel like, you know, it's my duty to try to at least present the other side and why I think that Lane got railroaded. And this is a public service. He's just been really honorable and a great guy. And I really think you should support him in any way that you can.
We'll all see it unfold. And you best believe, as soon as I find out about it, I'm going to cover it.
There you go. Yeah.
Lane's not going to tell me, but I'm going to find out, and then I'm going to cover it.